Who is Ricky Brown? You are Graves? You are Graves. And you are Thomas. Switch places for me so I don't. Okay. Gentlemen, all of you are charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
Please.
The nature of this case is a racing on a highway case, so I just want to let you know that these dim summaries will be separate for each defendant because they were stopped at different locations, if that makes sense. Okay. On April 17th, 2025, in Harris County, Texas, an officer was on routine patrol when he observed a Silverado pickup truck and a Cadillac motor vehicle accelerate at a high rate of speed side by side in an attempt to outdistance one another. The officer observed a third vehicle, a Dodge Charger, increasing speed while following the other two motor vehicles. The officer accelerated approximately to 108 miles per hour in an attempt to catch up with the three vehicles. The officer noted the posted speed limit on the roadway was 65 miles per hour. The officer notes that he was traveling at 101 miles per hour, maintaining view of the vehicles and recording the incident with his dash camera. The Cadillac and the Silverado truck exited the freeway, and the officer got right behind the pickup truck and paced it, traveling 85 miles per hour. A traffic stop was conducted on the Silverado, and the defendant admitted to the officer he was racing with the other individuals. While speaking with the defendant...
We're talking about Brown, right?
Yes, Your Honor. Okay. And while speaking with the defendant, the other two vehicles arrived on scene and admitted to the officer that they were racing along with the defendant. I guess that covers that.
Who came and admitted?
It says the other two defendants.
The other two came in.
Yes, Your Honor, that's what it states. I'd be happy to read the other. Sorry, it's just such a
I'm going to find that there's sufficient probable cause to go forward with your cases, gentlemen. Let me tell you now that the state of Texas and the wisdom of our legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from those who are arrested for racing. I have had cases in here where they have seized and taken a car from someone who was caught multiple times participating in this type of behavior. Don't do it. Do you understand?
Yes, sir.
If I find that you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you while this case is open. Living in a city as big as Houston without the ability to drive blows. Do you understand?
Yes, sir.
Each of you, none of you participate racing, street takeovers, donuts, reckless driving maniacally, or putting others' lives in danger. Do you understand? If I find that you're driving at 100 or something like that, it's just not going to go well for you guys. So do you mind filing conditions on each of, no racing, reckless driving, takeovers, anything of this nature, please?
Yes, Your Honor.
And then also, let's go through each one to see if they have valid licenses.
Yes, Your Honor. For defendant Thomas, we do have an eligible license.
Okay. Also, each of you you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must have car insurance. If you don't have either, you are not allowed to drive.
For defendant Brown, we do have an eligible license as well.
Okay.
And then for defendant Graves, the license is eligible.
All right. Gentlemen, do you have the ability to hire a lawyer, Mr. Brown? Okay. Do you have the ability to hire a lawyer? Okay, we're going to give you time to go hire a lawyer. We're going to give you 30 days. When you come back, please have a lawyer. I'm going to have you each go to Victoria, sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. We have enough death on our streets. Don't contribute to it. You understand?
Sure.
All right, come on, guys.
Well, all right, Judge, next is page 4, Castillo.
And those are all going to be states.
States, yeah,
Okay.
all of them states.
Go ahead and sign. Got it. Thank you.
All right, you are Jose Castillo.
Yes, sir.
Oh,
Mr. Castillo, you're charged with failure to stop, give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
thank you. The defendant was driving westbound on 9100 Willow Meadow at approximately 7 p.m. and crashed into a parked white Chevy Silverado. The defendant's right side mirror struck the left side mirror of the parked pickup truck. The complaining witness identified the defendant's vehicle with surveillance video and rode around the neighborhood until he located the vehicle. The complaining witness gave the address to the officers who went to the location. They met with the defendant, who stated he was aware he hit the truck, but was going to go back later.
Okay, Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If I find that something like this happens again, or if you pick up a new case or become a danger, I will revoke your bond and put you in jail. Do you understand, sir?
Yes, sir.
Eligible, Your Honor.
Okay. Mr. Castillo, do you have the ability to hire a lawyer? Okay, we're going to give you time. I'm going to have you go to Victoria, sign and reset. We will have you take a seat in the jury box while I get your bond conditions. Once you sign it, then you'll be free to go. Please.
I'm sitting on the back.
Good morning, Mr. Contreras. Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. The defendant and the complaining witness were in an Uber on April 17th, 2025, when a fight broke out. The defendant jumped on top of the complaining witness. The complaining witness and the defendant were dropped off by the Uber driver at the complaining witness's house. Once at the property, the complaining witness attempted to go inside. The defendant started a physical altercation where he struck the complaining witness with closed fists, causing pain and injury to the complaining witness. The complaining witness was able to get away from the defendant and lock the door with the defendant outside. The complaining witness has visible injury and bleeding of the face observed by officers who arrived on the scene.
Relation, and is there alcohol or dope involved? Just pled to an assault a month and a half ago, and here we are again.
Your Honor, the nature of the relationship, it states as a roommate of 2 weeks, and they were at a club known as Wagos on Washington Street. And, Your Honor, according to the dim summary, the complainant stated the defendant got too drunk.
Mr. Contreras, we are now going to handle whatever issues that are arising with you. If I find that you're another danger to the community, I will put you in jail. You're ordered not to consume alcohol or illegal drugs, and I'm going to put an ankle monitor on you so I know that you're not consuming. You are not allowed to go to bars, nightclubs, anything of this nature where alcohol is primarily sold. Do you understand? So I'd like to put a scram on him. Okay, yeah. Waive the fee. You're not to have contact with the complaining witness in this case. If I find that you do, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? What do you do with yourself these days?
I'm gonna take care of my, stepdad has taken away everything from us. So we're trying to figure that out. And that's why I moved in with Chris.
It's time for you to get a job. And I'm making that a condition of your bond. You're not doing anything and you have way too much time on your hands. So you're becoming self-destructive. This is now your second assault case within the last month and a half. No more. Do you understand?
Sir,
Can you reach out to the MAC for him, please? And then, you're not to be in possession of weapons as well. I'm gonna have you go to Victoria, sign a reset, and then we will have you take your seat in the jury box. You're gonna have to get with them for your bond conditions, then we'll get you a lawyer. Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off and on. The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face, and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
The stipulations of my bond. I know that.
On Crenshaw? Okay. I'm now entering in what's called a mattress order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up.
Yes, sir.
Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
Yes, sir. I'm currently looking for a job.
It's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes, sir.
You understand? All right. I'm going to appoint your lawyer. I'm going to have you go to Victoria Center, reset. We will have you take a seat in the jury box. I'm going to get you bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Let me check it.
Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay, Your Honor.
On April 17th, 2025, in Harris County, Texas, a law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. The law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Judge, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? Can you look to see any prior DWIs and if he has a license, please?
No prior DWIs and no license is eligible, Your Honor.
Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive. But like I said, don't consume alcohol. Don't use illegal drugs. You will be randomly tested. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back. For now, we'll have you go to Victoria, sign a reset. You'll get with pre-trial for your bond conditions and then you're free to go.
Thank you, Your Honor.
Mr. Brown?
So you are Ms. Martinez?
Yes, sir.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. No. I'm sorry, you're charged with DWI.
Yeah.
Okay, sorry. Wrong Martinez. You're facing up to 6 months in jail and or a $2,000 fine. You're charged with DWI. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent. Okay.
Thank you, Your Honor. On August 5th, 2024, a law enforcement officer was dispatched to a major crash near the 3753 block of Highway 45 in Harris County, Texas. The law enforcement made contact with the witness. The witness stated she felt force pushing her car, causing her to spin out and crash. The law enforcement officer made contact with the defendant. The defendant stated she was operating the motor vehicle when the crash happened. The defendant stated she was driving home from a friend's house. The law enforcement officer observed red, watery, bloodshot eyes, slurred speech, belligerent behavior, aggression, and lack of cooperation. The defendant continued asking for ice packs after having received them and was crying, yelling, and swearing at the law enforcement officer throughout the investigation. Standard field sobriety tests were administered. A 2 out of 6 was recorded on the HGN. A 7 out of 8 on the walk and turn, and the one leg stand was refused. A blood search warrant was obtained and executed, and the blood results came back to a .12.
Prior DWI?
Yes, they did.
We look at the out of county, please. Judge, I'm not seeing any prior DWIs here,
Okay. License?
and the license is eligible.
Martinez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, man? Do you have the ability to hire a lawyer?
No.
I can have you fill out an application. I need to know everything about you, how much money you make, how much money you have at the bank, what kind of car you drive, and I'll take a look to see whether you qualify.
Okay.
Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. We'll have you take a seat. Eventually, you're going to meet with pretrial services, and then we'll take a look at your application. Please.
Mr. Graves?
Mr. Martinez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, An officer observed a motor vehicle traveling at a high rate of speed. He observed the vehicle brake hard to slow down. The officer then got behind the vehicle and observed it to have an expired registration as of January 2025. A traffic stop was conducted and the defendant was identified by his Texas ID card. The officer approached the motor vehicle and observed the defendant in the driver's seat and the defendant to have glossy eyes, slurred speech, and an odor of alcoholic beverage. The defendant admitted to the officer that he had 5 to 6 beers prior to driving. The defendant stated he has a leg injury on his right leg. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 4 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The defendant stated that despite his leg injury, he does work out and have an active life. The defendant stated he was a 5 out of 10 level of intoxication on a scale from 1 to 10. The DIC was read and the breath test strip was refused. A blood warrant was issued and the blood draw was executed.
Okay. Mr. Martinez, can you run his license, please?
Yes, Your Honor.
I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. So if I find that you're using, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will put you in jail.
Yes, sir.
We are sending notice to DPS so that every single officer in this state knows that you're required to have an interlock in your car. So if you're caught wherever and you don't have one, officers will put you in jail.
Yes,
Do
sir.
you understand?
Yes, sir. Your Honor, can I speak?
Don't.
No, good. I got.
Don't. I don't want you to say a thing. Now's not the time. You have the right to remain silent, exercise that right. Just don't say anything. Don't. Do you have the ability to hire a lawyer, Mr. Martinez?
Not a phone.
Deputy Miranda's going to give you an application. We'll take a look to see whether you qualify. I need to know everything about you, where you work, how much money you're making, how much money you have at the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, everything. And then I'll take a look to see whether you qualify.
Judge, we have that the license is not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Martinez, and I'm telling you now, I don't give a rat's behind what your excuses. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This affidavit is what you're going to be signing, promising me you're not going to drive. Nothing in this world can justify you getting into a car and driving. Jesus comes down and needs to ride to church. Do not drive. You understand me?
Yes, sir.
Mr. Castillo,
Because you don't have a license, because you're not going to drive, I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming.
That's what I was gonna talk to you about. I was talking about my bond conditions.
Mr. Martinez, in the last 1.5 years, you have had 1, 2, 3, 4, 5. You are on your 6th case within the last 1.5 years. There's nothing at this time that you can try to negotiate with me. Do you understand?
I understand, but it's about work.
Stop. All I want is my streets to be safe.
Yes,
And
sir.
if I find that you're in danger, anything 1 iota, it's just not going to go well for you.
I understand.
Okay, do you mind giving an application and we'll have you swear to us?
Cool.
Are you with Thomas?
Yeah, I can.
Oh, yeah, we never got Thomas's.
Gary and Thomas?
Yeah, I'll meet them.
Raise your hand.
Ready?
Mr.
Mr. Gallegos.
Daniel Martina Pedraza.
And bless him.
good morning, Your Honor.
Page 9?
Yes, Judge.
Okay.
Morning, Judge.
How are you?
It's very good.
Happy Friday, man.
Hi.
Did you say Martina?
Martina Pedraza.
You, hey, this is now not the time for you to talk to him about this. You are Martina Pedraja.
Yes.
You're charged of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle stalled in a moving lane of traffic. The law enforcement officer approached the vehicle and found the defendant in the driver's seat asleep with the vehicle running and foot on the brake pedal. The law enforcement officer woke the defendant up and noticed a mild odor of alcoholic beverage, slurred speech, and glossy eyes. The defendant admitted to consuming alcohol. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN was recorded. A 7 out of 8 on the walk and turn. A 3 out of 4 on the one-leg stand. The defendant consented to breath and blew a .157 and a .154.
Can you look right at the eyes and licenses?
Yes, Your Honor. So
Mr. Martina, will to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, and I'm going to randomly test you. If I find that you're using any alcohol or illegal drugs, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it hourly, if they find you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
¿Se lo entiende?
Yes, sir.
Yes, sir.
If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is also a bond condition.
Your Honor, we have no prior DWIs, but the driver's license data is not populating at all. There's no indication.
No indicación.
No license.
No license, Judge.
Dice no tiene licencia.
Do not drive, Mr. Martina. You will be signing an affidavit with me today promising you're not going to drive. I don't care what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Nothing in this life can you say that will justify driving. Do you understand?
Yes, sir.
Temptation is big. Just don't do it.
Okay.
So for now, I'm going to have you come up here, swear to us that you're not going to drive. We will get you to Victoria where you will sign a reset. You will eventually get with pre-trial for your bond conditions, and after that, you'll be free to go. Because you have a lawyer, I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me that he cannot get a hold of you because you're ducking and dodging phone calls, text messages, I'm going to issue a warrant for your arrest. If they call you to go take a drug test and you fail to appear, a warrant for your arrest will be issued.
Yes, sir.
All right, come on.
Hey, Judge.
Thanks.
Here is something I want every one of you to think about. Today, we watched 3 men get pulled over for racing at over 100 miles per hour on a public highway. And when one of them got stopped, the other 2 drove back to the scene and voluntarily admitted to the officer that they were racing too. The judge told them plainly, "Texas law makes it easy to seize your car if you keep doing this, not impound it. Take it." So here is the question. Street racing is one of the few offenses in Texas where the state can permanently seize your vehicle as the instrument of the crime. Most Americans assume the Constitution protects their property from government seizure without a conviction. But in Texas, civil asset forfeiture laws allow the state to take a car used in racing even before a case is resolved. Is that the right balance between community safety and individual property rights? Or does the punishment reach further than the Constitution intended? 3 men drove back to their own traffic stop and told on themselves. The law they may not have known existed could cost them the cars they drove there in.
Bless him.
Yes, Your Honor.
The costume on this
Yes, Your Honor.
is 2560811. You are Miss Morales Vega.
Yes.
Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, an officer was working in an undercover capacity in plain clothes when he entered a sexually oriented club and sat down at a table. The officer engaged in conversation with the defendant. The defendant agreed to participate in oral sex with the officer for a fee of $400. The officer notes that the conversation was recorded. The arrest/enforcement team detained the defendant and took her into custody without incident.
Ma'am, I'm going to find that there's probable cause to go forward. I'm ordering you now as a condition of your bond for evasion is lifetime behavior. If I find that you do, I will revoke your bond and put you in custody, ma'am. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with and then you get shipped off to immigration. Do you understand?
Yes, sir.
Can I provide you a lawyer today? Would you like a lawyer?
I have an attorney. ¿Quién es?
Are they supposed to be here today?
Not today. Lo ocupo. ¿Ocupas phone?
Sí, pero me dijo como que no tenía que presentarse con ella.
She said she hired one, but he's told her that he did not need to be here today.
Person hasn't filed any documents. I don't
No,
know.
de documentos.
I mean, I can, if you would like, I can give you more time. I'm happy to give you a court-appointed lawyer today if you want one. You tell me what you'd like to do. I can, reset you and give you more time. Normally lawyers file documents.
Give me another tape.
Okay. Like I said, if you want a free lawyer, I'm happy to give you one today. So if you have problems when you're out there, you can come back and we're happy to give you one.
Ahora regresan, yo tengo uno que
I have one.
Okay, that's fine. I just, hopefully they'll come here for the next setting. I don't know. For now, I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you take your seat in the jury box while we get your bond conditions. We're going to have you sign them, and after that, you'll be free to go. Do you mind filing your conditions, please?
Absolutely.
No engaging in this.
Page 17.
You are Mr. Rosabal Matos.
Sí.
Yes.
Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge. On April 19th, 2025, in Harris County, Texas, an officer observed the defendant run a red light on North Shepherd Drive. The officer then observed the defendant's vehicle fail to drive in the designated lane, striking the raised median and causing his tire to go flat. A traffic stop was conducted. The officer made contact with the defendant and observed the defendant to be the driver and sole occupant and to have bloodshot eyes and slurred speech. The officer could smell an odor of alcoholic beverage emitting from the defendant's vehicle and from his person upon his exit from the vehicle. Officer Castrejon spoke to the defendant due to the defendant being a Spanish-only speaker. The defendant admitted to consuming one beer. Standard field sobriety tests were conducted. The officer noted a 2 out of 6 on the HGN, but also noted that the defendant would not follow the stimulus during distinct and sustained nystagmus at maximum deviation. Therefore, the officer was not able to observe the clues on that basis. The officer noted a 3 out of 8 on the walk and turn and a 3 out of 4 on the one-leg stand. The DIC was read on a recording in Spanish at the Joint Processing Center. The defendant consented to a breath test. The 15-minute waiting period was observed and the breath test came out to a .161 and a .153.
Any prior DWIs and a license?
No prior DWIs, Judge. I'm checking on the license.
Tengo licencia. Find that there's sufficient probable cause. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If you're not in this country with proper permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with and they get shipped off to immigration. They sleep it daily, hourly. So behave while you're in this country. You get no more warnings from us. Do you understand? If you do not have a Texas driver license and liability insurance, you're also ordered not to drive.
I do have.
Judge, it appears that it is eligible.
As long as you have a valid license and liability insurance, car insurance, then you will be able to drive. That is also a condition, that you maintain liability insurance. Do you have the ability to hire a lawyer?
No.
No.
I can have you fill out an application, but I need to know everything about you. I need to know what kind of work you do, how much money you make, how much money you have at the bank, what kind of car you drive, any other sources of income, and I'll take a look to see whether you qualify. For now, Deputy Miranda's going to give an application. I'm going to have you go to Victoria, sign a reset, and then we'll have you take a seat in the jury box while we take a look at everything. Please.
Calling me on Monday because I'm before margarita.
You are Mr. Vera Quiroz.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, an officer responded to a call for service for a possible failure to stop and give information in Harris County, Texas. The witness stated to the officer that he observed the defendant strike a maroon 4-door sedan from behind, drive around the vehicle, and then drive away from the scene without stopping to provide any information. The witness followed the defendant and observed the defendant to increase and decrease his speed frequently, failed to drive in a single lane of traffic, and nearly strike other vehicles until his car became disabled on Highway 249. The witness observed the defendant to exit the vehicle and to be the sole occupant and operator of the vehicle. The officer made contact with the defendant and observed a strong odor of alcoholic beverage, glossy bloodshot eyes, and poor balance. The officer detained the defendant, and while removing a pocket knife from the defendant's pocket, the officer observed a bulge and a plastic feeling in the defendant's pocket. The officer observed a faint odor of marijuana, so he removed the plastic bag, which did in fact contain a usable amount of marijuana. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The DIC audio was played for the defendant, and the defendant agreed to a breath test, which yielded a .148 and a .143. The marijuana weighed approximately 0.2 ounces.
Priors, no license. Mr. Vera,
No priors, Judge.
okay.
No driver's license.
Mr. Vera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. With you, I'm going to test you 50 days from today. If I find that you continue to use marijuana, I will revoke your bond. I'm going to put you in jail. If you're not in this country with proper documentation and you go to jail and immigration finds you, they will put a detainer on you because they sweep it daily. Do you understand?
Yeah.
Yes.
You are not allowed to drive if you don't have a Texas driver license and liability insurance. That is also a condition of your bond. You do not have a license, you will be signing an affidavit with me today. Mr. Vera, in this short life that we have, do not drive, because if you do, you will pay dearly. Do you understand? This is a promise that you're going to make to me, that you're documenting that you're not going to drive. Nothing you say can justify driving at all. Do you understand?
Yes, sir.
If you get a license and insurance, come talk to me and then I'm happily will take this off. But until that point, you do. Do you have the ability to hire a lawyer? How old are you, Mr. Barrett?
No.
23?
Do you work?
Yes.
Do you have the ability, do you have the funds to hire a lawyer?
No.
If you want, I can give you an application and you can apply for a court-appointed lawyer. I need to know everything about you and I'll see whether you qualify. Above all else, do not use, because it's really not going to go well for you. Do you understand? Okay. Deputy Miranda's going to give you an application. I will have you go to Victoria Sign and Reset. You're eventually going to meet with pretrial services for your bond conditions. After that, we'll take a look at your application. Come on. Do you need the clause number on this, Blas?
Yes, Your Honor, please.
560926.
26?
Yeah, 0926. Mr. Aiko Stoll, you were charged with tampering with a government record. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, a law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, and the officer initiated a traffic stop. The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he say that? Read it to me again. I zoned out.
No worries.
Please.
The law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, so he initiated a traffic stop.
Okay.
The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he ask him if he put the tag on there? Did he ask him? I mean, let me see how it's charged. Did then and there unlawfully, intentionally, and knowingly present the thing attached hereto as Exhibit A with knowledge of its falsity and with the intent that it be taken as a genuine governmental record. That's a specific intent crime, you know, somehow you have to show me that he knew of its falsity.
Look at it.
Judge, I'll just read straight from the DIMS. I met with the defendant and informed him of the reason for the stop. I then asked for a Texas driver's license that provided me with a Guatemalan ID. I then asked the defendant when he bought the vehicle. He advised me that he bought the vehicle 3 months ago. When I asked the defendant if he has the title to the vehicle, he then advised me that the guy who sold him the vehicle still has the title. The defendant stated that he bought the vehicle 3 months ago again. When asked for the title, he stated that the guy who sold it still has the title again.
I'm going to find that there's no probable cause to go forward with your case, Mr. Acko. If you do not have a Texas driver license, you are not allowed to drive. At some point, if you continue to do things that may break the law, you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck. If, I don't know what your immigration status is, but if you're not in this country with permission, you must live like you have a halo above your head. If not, there are serious consequences. Do you understand? Please take a seat. You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm gonna find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today and you can give your side to the lawyer. Okay? But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm gonna have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm gonna allow it. Okay? Just don't. So we're gonna try to do work on our side or their side to see if they can reach out to her and see if she's okay with contact with you. So. Let me see.
Morales Vega?
Okay, so hey, do you mind reaching out to the MAC for Mr. Mukes? I'm gonna get you a lawyer here for you soon. I'm gonna have you sign a reset with Victoria. We're gonna have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and hell.
I know there are two sides. Mr. Mukes,
I'm the one who called them for help and they locked me up and violated my rights.
hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Stop. Don't. Please. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Your Honor, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol.
And then
Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's just coming, so that's the odor of alcohol.
Come on, man.
That's what, no, that's, I'm just saying, I mean, that, the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge, but I've never had it.
You're killing me. You're killing me, Smalls.
Your Honor, the law enforcement officer does state, in the DIMS that there is, a distinct odor of an alcoholic beverage, distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah,
That's
That it?
all we have before we initiated the standardized post-firing test.
okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears. You know,
So,
we have enough death on our streets now, you know? $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank. Anytime something where they're going to be supervised, pretrial does it, so you don't have to.
Thank you.
You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18th, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking. The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with your case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs, and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I will have you go to Victoria, sign a reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right.
And this one is about second chances and where they end. Today we watched a judge revoke the bond of a woman who had been in a pretrial intervention program for a DWWI for over 500 days. She tested positive for alcohol, picked up a new case, and was removed from the program. The judge looked at her and said, "I'm not throwing you to the wolves. I want a TR evaluation first because something is going on, and I want to figure out what before this becomes a felony." So here is the question. Pretrial intervention programs are designed to give first-time or low-risk offenders a path that avoids conviction. But when someone repeatedly violates the conditions of that program over 500 days, and then picks up a new case while still enrolled, at what point does continued intervention become something the system is doing to protect itself rather than the defendant? And is a judge who still insists on an evaluation before revocation fulfilling the law's promise of rehabilitation, or extending grace past the point it can be justified? The judge chose evaluation over incarceration. That bet is made on faith. The TR will tell us if the faith was earned.
All right. Good morning, Ms. Simmons.
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear of when she's trying to get home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess your weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay, I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with Pritchard for your bond conditions, then we'll have you meet with someone shortly.
Okay, thank you.
You are Mr. Walker.
Yes, sir.
Mr. Walker, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-trial for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. Please.
Your Honor, we have that the license is eligible.
Is that the last one?
Judge, that, for now, yes, I think I have 2 of them set for arraignment with attorneys that are recruited.
Okay. Mr. Walker, or do finish that, and then I want to tell you something else.
Judge,
Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand? Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I'm trying to get a real good understanding. That's why I want to ask the question.
A lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please.
Evidence was on my phone.
I've granted all the ones that are. All right, good morning, Ms. Arena.
Hello, how are you today?
We took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed, and you are at a bond denied status now, meaning that you're being held at no bond. So what we're going to do is we're going to do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
That's for what?
You're now charged with driving while intoxicated.
Now, see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent. Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes, sir.
We're going to do probable cause. Like I said, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint you a lawyer after we do probable cause to you. You can speak to someone here momentarily. Okay? So let's just do this real quick and then, okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, sir. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer try to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the dim sum record. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or legal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DWIs, I guess, as well?
There's no prior DWIs.
Okay. License?
And the license status should be ready for my review. Pulling up. It is. Trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer and let me have you talk to the lawyer. And then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You
Yeah,
understand?
just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because are you ready for conditions? Okay, take your time. No rush. Okay.
That's fine.
You are on bond for a tampering case and you've now picked up a burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14, 2025, in Harris County, Texas, a law enforcement officer was flagged down by the complaining witness. The complaining witness advised the officer that a male had just broken into the complaining witness's motor vehicle and drove off in a different motor vehicle. Another witness observed the defendant break into the complaining witness's motor vehicle and provided cell phone video to the police. Additionally, the complaining witness observed the defendant break into his motor vehicle and chase the defendant through the parking lot. The officer pursued the defendant on foot. The defendant was detained and positively identified by both the witness and the complaining witness. The defendant admitted to breaking the complaining witness's window.
What time of day or night was this? Or was it during the day?
It's in the daytime, it appears, Your Honor, but also, like, when you read the summary, it looks like an officer detained him on a bicycle and that he was wearing different clothes from the description of the foot pursuit, that clothes were ditched.
I don't know.
So then they did a drive-by identification of the suspect.
Mr. Robinson, what is the one thing I asked you not to do? The one thing I asked you not to do. Not be a danger to my city or pick up a new case. You've now picked up a very I'm going to find that there's probable cause to go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on him.
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives, works. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you endanger my city again, I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have a,
Today, I'm not sure how to pronounce that, but
That's right.
yeah, I think he left already. But I was wondering if we could rehear PC.
Okay.
Oh, he did? Oh, okay. I'm sorry.
But I hope, because I had asked him to reach out to the complaining witness just to make sure that she's okay.
Okay.
Because if she,
One issue there. So because it was resisting, it's not in our system. Her contact information is not in our system. Now, when the offense report comes through, it should be. Problem is we don't have that offense report yet. I'm going to keep checking it. I can try to run through RMS.
I mean, until I know, yeah, that's Mr. Mukes right there. So until I know, I'm going to order no contact because I don't know, because she was scared of him there, you know?
Uh-huh.
So,
I understand. I was wondering if I could, I'm just approaching on PC for it. Yeah, but
oh,
to rehear PC, yeah.
okay, sure. Do you mind reading it again? Please.
Officers were dispatched to a disturbance call on April the 19th of 2025. Officers observed the defendant to be outside of the residence with what appeared to be an injured hand. Defendant stated he had injured his hand while punching a wall when he was in an argument with his wife. Defendant stated he was drinking, quote, Crown, and requested medical attention to the scene. Officers attempted to make contact with a female at the residence who refused to open the door. She only stated that the defendant should not be at the residence and that she was in fear of the defendant. Defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. Officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, officers attempted to place the defendant in custody for public intoxication.
Here's my problem. I didn't have a problem until that point.
Right, I understand that, Your Honor, but if the police are arresting him for public intoxication, the front door is not a public place under the statute or under case law or under the
It's outside.
definition. It doesn't
That's
matter.
right.
It doesn't matter. It doesn't fall within the definition of a public place. Public places are where multiple people go through. They're common areas. It's not a public place.
He's not in his house.
It is his residence. It's
No,
his
he's
residence.
outside.
He's outside, and I would argue,
He's
Your Honor,
outside. He's not inside the house. He's
He's
outside.
right at the front door, and so.
I mean,
Your Honor, I would argue, a mailman goes to the front door, the other packer goes to the front door.
I don't think under the statute it qualifies. I mean, I have.
show me a case that
Sure,
says
I have the definition.
or is,
Right, I have the definition of a public place under
I
the
know what
Texas
the
Penal
definition of
Code.
a public place
So it's
is.
like apartments, hospitals, libraries, schools, office buildings, sidewalks, like driveways, the public road, not the front door. I mean, even the police, like, there is a reasonable expectation of privacy of going into the front door of the house. Like, it's not really considered a public place under the statute.
Show me case law, because I don't know. I mean,
I'll try, I can find.
I know I know the definition. I've seen the
Right,
definition,
yeah.
right? But show me something that says that being, near the front door is private property, so it's not.
I mean,
Right.
at the front door. I mean, that is like, I mean, people have a reasonable expectation of privacy in their home, like.
In their home,
Right,
yes.
and at the, like, even at the very, like, front of the door, I mean,
We don't know exactly where he is.
but that's what the DIM says.
Okay,
Your Honor, what I would say, he's clearly not in the house, he's at the front door, he's threatening to kick the door down after they had just gone out on a domestic related call. And she said he appeared to be intoxicated, he defended himself, told officers that he was drinking Crown. They decided that based on the facts, he was a danger to himself, and they decided to place him in custody for public intoxication.
Mr. Mukes, coming up.
I'll turn the live stream off.
To have, I mean, Brenda wants to, I heard we can't. She's have a comment? She's not calling. She can find out.
Right, I said, the message is good, so get a quote about how you get here each day.
You know what I mean? So you let her know, if mom doesn't have to be contact with her, doesn't let her know to come in and piss.
Work, you can make them bond it.
Yeah, I'm not, hey, let her know we're not gonna play games. I don't care.
Mr. Marlon Simmons, Your Honor. This was a DWI PTI that went south.
Eight,
Why for a plea?
was tested positive for THC, and alcohol, and they just picked up a charge out of Waller County for operation of a salvage vehicle on a public roadway.
Okay, so this case is 517 days old. Do you have an offer on the case?
Yes, Your Honor. This was a 12-month probation since it's been kicked out of PTI.
Okay, so you must either accept the plea bargain from the state or I'm going to set your case for trial today. So they've offered you a 12-month probation. You talk about it with Mr. D to see if that's something that you want to do, because I don't know. Is that the
He's
only
got it.
offer you have?
That's the offer I've made, yes. That's the
Okay.
offer for now.
So,
He's already spoken with me, Judge.
so you let me know what you want to do.
The plea is ready for right up there.
Yes.
Yes, sir.
Oh, I didn't realize.
Yes, sir.
Okay.
And that's straight probation, Your Honor.
I'm going to tell you now that we've repeatedly asked you, we've repeatedly ordered you not to use. So you either don't care about the bond conditions or you got a problem. And I'm going to tell you now, we put someone in residential treatment kicking and screaming that they didn't want to go yesterday. So if you continue to test, I can modify your conditions to put you into an inpatient treatment program at a minimum of maybe 3, 6, 9 months, maybe a year and a half, depending on how well you respond to treatment. Do you understand? So, and I'm telling you now, I will test you like crazy. The first instance you use, it's not going to go well. I will issue a warrant for your arrest. We will have a hearing, and if they prove it to me, because I'm not letting you go until the act is clean. Do you understand me, Mr. Simmons? This system will not fail you. The agreement that you have worked out is 180 days in jail to be probated for 12 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. Has he done a TRAS yet?
They recommended supportive advocacy.
Was that the
The
way?
Mhm. Okay.
Let's do a new one.
Stop it.
Substance abuse treatment as required by the TRAS. No breath test refusal, meaning that if you're pulled over, an officer asks you to take a breath test, you must do it while you're on this probation. No drugs, alcohol, and a guardian interlock.
Judge, with respect to the guardian interlock, client has informed me that he does not have a vehicle at this particular time. So I will respect request that the board allow him to use the portable device in lieu of the guardian.
I'm okay with that, but I'm telling you now, Mr. Simmons, that you will be signing an affidavit promising you're not going to drive. I don't care what your excuse is. If Holy Mother Mary comes from and asks you for a ride from church, you drive. You can be facing an additional 6 months in jail on a contempt and a $500 fine every time you drive. Do you understand?
Sure.
Do not drive. Is it because he doesn't have a license?
He does not have a vehicle, he informed me, Judge.
Do you have a driver's license?
Yes, sir.
Okay. We are sending notice to DPS so that every officer in the state knows if you are in a car driving, you are to have a guardian interlock, a breath test device. If you don't, you're caught driving a car. They're going to put you in jail. Don't be sneaky. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this. The other thing, Mr. Simmons, is this now will reflect as a conviction on your record. You ever get pulled over in the future, be it 20 years from here, 30 years, you even have the faintest smell of alcohol or dope, they're going to see this DWI. It's probably not going to go well for you. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty, and I'm guilty. I'm going to find you guilty. I'm going to send you to this agreement. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Dean. Bioji,
How are you?
the man, the myth, legend. How are you?
I'm doing quite well.
How's our boy?
Well, that's why I'm here.
He was removed from the project.
Oh, I was just like,
Yes, Your Honor. So we are interested in pleading, this case out today.
what's the last name again?
All right, well, I think they reversed the name, so I think it should be Segun as the last name.
Was there restitution that was owed in this case?
No, Your Honor, it looks like, I'm just checking now, it was a single vehicle accident.
Okay. What do you think?
I'll look at the regret, Judge. I think they expressed interest in giving me a deferred or getting a deferred.
Deferred?
And I'll explain why, Your Honor. Time served was offered, and that would be the most convenient route. He doesn't have to worry about anything. I gave him that option. He still is interested in trying to get his record sealed for employment reasons. And so,
We have literally had a problem with Mr. Bada the entire time he's been on bond for this case. So to think that something would actually change just because he's on a magical deferred, which was before, this was a way for him to get it dismissed, and he couldn't even do this. Now are we actually going to hope and pray that he's going to make it deferred? As if
I think, one thing is.
I don't think so.
With being on the courts deferred, there's more teeth to it. Because once he enters into that, now he's exposing himself to, incarceration if he doesn't succeed.
I would just as well move on, really. I mean, he's gonna pay a bunch of money to get on this deferred, and then he's gonna come back and say, oh, I don't have money to do this, I can't do this class, I can't do that class, and then I'm out and wherever I'm, in whatever state I'm in, you know, just really, just let's be done with it. I mean, you know, you can lie to us, but you can't lie to yourself. And really, if you couldn't even make this, you couldn't even make it while you're on bond. We literally had bond violation after bond. Patient, no.
One more, matter for
Sure.
consideration. He did complete, if I'm not mistaken, all of the classes. He did do, some level of completion on the PTI. It wasn't as if he, completely disregarded everything. I think the matter, of what led him being removed has always been consistently the guardian interlock blowing into it on a consistent basis.
Then if he can't even blow into it here, this is one of the basic tenets of being on probation. So we are literally gonna put him on for the same thing, and he's still gonna have issues. You know,
Sorry, Your Honor.
I have so much drama in my life now, I really just don't need it anymore. And you have really gone above and beyond the call of duty with him regardless as it is, you know?
Understood, Judge.
Really, I mean, you're pro bono, it just, no, it's over,
Yes, Your Honor.
please.
We'll try to work it out. Thank you, Your Honor.
Okay. Oh, there's no one here. Come up, Ms. Torrance. I'm okay with everything but one thing.
What's up?
What happened with Ms. Torrance? Picked up a new case?
It was a failure to ID, and I'll pull it up now.
She actually had this one.
She has other statements.
I do apologize. I was trying to pull a arm as judge, which is now.
Take your time, Blaze. There's never a problem. Can you read to me what happened on the failure to ID?
April 22nd, 2025, officer dispatch in reference to a. In reference to an earlier motor vehicle, complainant stated that at 4:30 a.m. she heard a car alarm go off and looked out the window and saw two individuals leaving.
Oh my God, you're telling me this is a BMV?
No, it's not being beer.
That's the co-defendant,
It's the
Judge.
defendant.
She's with, this is a party.
Not charged though, Your Honor, say that, but, complainant approached the suspect and defendant Silva stated that she was, quote, going to beat her ass if she kept following me. Complainant was able to flag down an officer, and the defendants, the other complaining witness, the owner of the vehicle stated that the officers, there was a red paint on the front seat of the complainant's motor vehicle. Complainant observed that a bike that defendant Silva was riding on had red paint on the seat. In the back of defendant Silva's pants was also red paint. During the investigation, I observed defendant Silva with red paint on the back of her pants. During the investigation, defendant Silva admitted to going to the vehicle to find things changed. Once the defendants were detained, officers asked what the defendant's name and date of birth was. She first stated that her name was Sierra Johnson, date of birth 4/18/2002. Officers asked for a clarification on the spelling. Officers then asked if she ever had a Texas driver's license or ID. She stated she did not. Officers ran the given name, but nothing came back. Officers then called for Moga Davis. While officers were waiting, he asked the defendant what her name was, and she said that her name was spelled Sierra, Ceirra, with a C instead of an S, and that Johnson was her mom's last name, and that her real name was Torrance. Officers ran the new name and Texas driver's license came back to defendant Torrance with multiple City of Houston Precinct 2 warrants. Plastic center.
So the co-defendant got charged.
They're going to charge Your Honor. I'll pull it up now.
Why not Ms. Torrance?
From what I could read in here, Judge, I don't want to speculate, but I think all of the evidence can point to the co-defendant. And in fact, co-defendant admitting to going into the vehicle.
There was red paint in the car.
Right.
She has red paint on her.
That was,
No, that was co-defendant. I don't.
Was she acting as a lookout?
I don't know why you did not take a B&B on this. I don't want to speculate. All I can see is that obviously there was a decision made and take that they didn't have enough for B&B, but they had.
Anna, as much as I love you and as much as I appreciate your tenacity, no, there's something going on that's a lot deeper with this, and I'd like to find out. And what I'd like to do is have her TRS, essentially, but I don't know what we need to do to get through to you, Miss Torrance, but apparently of all the stuff that we've dealt with now, in your case is what? $241 days, and yet we.
Judge, if I may, this is a DWI. We got the alcohol report back and they sent it off to get tested for tox. We still do not have that toxicology report. And when we were.
I get it.
Okay.
I'm not saying.
It's just, she's not the one dragging it out. It's been waiting on the test.
You are on
Yeah.
bond. You've now picked up a new case. I've repeatedly asked you to behave yourself while on bond. That you are not charged with 2 cases and you merely have the one. I'm now revoking your bond number, DWI, and I'm taking you in. And what I'd like to do is have her TRAS immediately to see how we go forward, because this is, in my opinion, throwing her to the wolves, because something is going on and I'm going to try to nip it before it becomes felonious.
Judge, we do have an alternative offer on there. That would include the TRS.
Yeah. I want to do it first,
Absolutely.
so we see how to go forward, because I don't want,
And while we're here, actually, let me talk to the state about this before I'm gonna give them a heads up.
I have Ms. Aristelsi on today's docket, Judge. She had bond violations.
I bring her up.
Ms. Aristelsi, come on up. And Judge, she missed a drug test. She tells me that she had lost her phone at that point, and so that's why that she did not know that she was notified for a drug test. I have submitted. Oliver Aristelsi. Aristelsi.
Aristelsi, a la torre.
And Judge, I have submitted a mitigation packet in the DWI application. She's interested in doing the PTI.
So I'm sending you now for a drug test, a drug and alcohol test.
Yeah.
Mr. Vada?
This is your second bond violation report. I'm well within my right to just take you into custody now. And if you ever have any more violations, I don't care what it is, you will go into custody. And the next time, your bond will hit the clouds. Do you understand?
Yes, sir.
So I want to send her for a drug and alcohol test, and then we'll come back on Monday so we can assess what the results are.
Just roll to Monday, Judge?
Please take it.
We're ready to plead, Your Honor.
Okay. Coming up, Mr. Bada. So we need to make sure that this is the right name. Is it? What is your first name? Okay, so Bada is your actual last name.
And I'll send it in.
Right. Mr. Bada, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement that they're offering you 3 days in jail with credit for the 1 day that you have done. You are giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there forever. From now on, you are facing a minimum of 30 days in jail. You pick up any more DWIs. And I'm going to tell you, because it's going on your record, you get pulled over and you have anything funky to smell, whether it's weed, whether it's alcohol, what do you think is going to happen? If you want to get lit, if you want to smoke until your heart's content, don't get into a car. I know that he has done above and beyond the call of duty in representing you without probably taking it. For all the money that you have saved, $50 will get you a ride to wherever you want to go in this life. Do you understand? I don't know if I'm going to waive the supervisory fee with him. I don't know if he's truly indigent or not by OG. I know that you are, but I don't know. You know, I know that you've been throwing everyone for a loop the entire time, and so I want you to fill out an application from where you saw. I know that you are truly indigent. You're going to swear to this document. This is a public, not a public, but this is a governmental document that you're going to swear to. I want to know about your financial situation. I want to know everything about you. How much money you have at the bank, how much money you have coming in, how many cars you have, and then we'll take a look to see whether you're truly indigent. You understand? I'm going to suspend your license for 180 days. Do not drive until you get a license. So we will have you fill out an affidavit and I'll see whether you are indigent and then we'll take a look. But really, this dude is really gone above and beyond the call to represent you for all the issues that you've had. So thank you so much for doing what you're doing. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement. Deputy, do you mind giving an application so we can work to see? Okay.
And Your Honor, do you need me to approach with?
No, I'll look at the document. If he does, then I'm going to waive it. If you do not qualify, you will be required to pay the supervisory fees. In this case, that is $3,000 plus court costs. Actions have consequences. You had the opportunity. When you pick up a DWI, you're going to pay for it one way or the other. You know, now this, with the conviction, it's going to follow you forever. All I hope is that 20 years, 30 years from now, this was enough of a hassle in your life that man, I had 3 beers. I better not get into a car. Time heals all wounds, but the law never forgets. Good luck to you.
Thank you, Your Honor.
Bye. You got all the conditions on Robinson, right?
Yes, Judge.
Yeah, okay, good.
We're just waiting on the sheriff to bring up Mr. Randall.
Yes,
sir. Heads up, Your Honor, Mr. Randall's,
I'll jump on Zoom.
got a lot to say.
I don't think anything.
You got a lot to say?
Yes.
It's okay.
Understood.
Are we doing a plea?
No, so he picked up a new charge, had a failure to ID from a couple of years ago, 2022. Has been your back and picked up a new charge.
So that's the only reason?
Yeah.
Got it. Okay.
But yeah, he wanted to speak to you anyway.
I'm happy to talk. Absolutely. Is that you going, bringing him on? Okay.
Yes.
Come on up, sir. How are you? So Mr. Randall, you're charged with failure to identify oneself as a fugitive from justice. That is a Class A misdemeanor. That was from 2022. And I guess you didn't show up for the arraignment, I'm assuming, so we revoked the bond, we issued the warrant. 3 years later, now you've picked up an assault bodily injury. On that one, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I don't know what happened in the assault, so we're going to find out. Okay, what happened?
Judge, before we get started, there is some use of profanity that's pertinent. How do you prefer to?
Dude, we don't have virginal ears. You can do whatever you want. Say it.
On April 22nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an assault in progress call and made contact with the complaining witness. The law enforcement officer observed the complaining witness to have blood on their face and fresh cuts on his face and near his eye. The complaining witness stated he walked on a bridge and passed the defendant and told him to have a good day. The defendant then stated, "What the fuck did you just say to me? You got a problem." The complaining witness told the defendant that he didn't have a problem and did not want any trouble. The defendant then got into a fighting stance and struck the complaining witness in the face multiple times, took him to the ground, continued striking him, and stuck his finger in the complaining witness's eye. The complaining witness stated he was in fear for his life. A witness corroborated the complaining witness's story.
Any damage to the eye?
Law enforcement officers took pictures of what he recognized to be a bite mark on the complaining witness. I will look for further damage evidence. The officer observed the complainant's eye being red and the bottom part of his eye having a fresh cut and abrasions on both sides of his face and above his forehead.
Okay, Mr. Randall, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. I don't know if you're going to bond out, but if you do, I'm going to put a monitor on your ankle because you're a flight risk.
Not gonna go anywhere. I mean, the assault,
So
charge.
don't talk about it, really. You have the right to remain silent, exercise the right. That's why you have a lawyer, because whatever you say now, they're going to sit there, type it to try to use it against you. Just best not. So the problem is that I can't give you a PR bond. We gave you a PR bond last time and you take off, or you took off. Now, 3 years later, you picked up a new case. And the only reason we have you back is because of this. So I can't just give you another PR bond, you know?
And Your Honor, Mr. Randall would like me to communicate to the court that he was under the impression that his prior offense was dismissed and it was a misunderstanding, but that he has every intention to satisfy his obligations.
I get it. I understand. Where do you live?
I believe he's kind of in transient at the moment, Your Honor.
And that's a problem because I don't want to just give you another PR bond and you're going to end up on the street. You know,
It's hard to get lodgings here.
Allegedly here, they're just wishing you to have a good day. Have a good day. And now, you know.
We have provided him with resources in order to try to find lodging and the like. So I think you said you were going to take advantage of that information I gave you.
Yeah, I'm sorry, I can't. You know, you scare me. You know, you take off. And the only reason we have you back now is because of have a nice day.
No, I didn't take off. I've been right here in the city of Houston. It wasn't a flight risk or me ignoring the conditions of the PR bond. I showed up to the court. Like I said, the discrepancy said just with the criminal justice system up to this point is paramount to pretty much everything.
Who do you have in your life? Where's mom? Where's dad? Where's brother, sister? Who do you have in your life?
I'm on my own. I actually came here to Texas to take care of VA and Social Security disability to acquire a resource to just take care of that simple business and go back to Germany. That was it.
Germany, he said, Your Honor.
But I'm not a recluse or a loose cannon. How they trying to paint? It's wrong. That guy. Don't talk about the facts.
So if you had somewhere to go, like family members that are willing to take you in, I would consider. But just to go back on the street. My fear is that we let you out and then the same thing happens again, where you just go out and then we just don't see you again, you know? So I don't know if you can somehow try to reach through some family or anyone that he may have, talk with them, and then I guess we'll go from there. Okay? All right. Good luck,
We're
sir.
asking for a short recess. We spoke with the
Absolutely,
state.
for sure.
We'll try to resolve this.
Maybe a couple days or however long you want. And
So,
yeah. All right. Good luck, sir.
thank you. Comes out right.
Judge, can I call up the arraignment?
Hey, Nathan, can I do an arraignment real quick?
Well, I'm just gonna take a minute of your time.
Okay, come on.
Hi,
Great to
Judge.
see you, man. What's
Pleasure.
up? Happy Fridays?
Yes, yes, Judge.
Morning, gentlemen.
So these are two U of H pre-law students.
Great.
All right, so Peter and Elijah, their class is getting a tour of the building, and when I was taking them downstairs, they had mentioned that they had seen you and they wanted to meet you.
We saw you on so many times on TikTok, and it's a great honor.
Yeah, I don't know who puts I don't put it on there, so I have no idea, but
You've gone viral, like I've seen so many times, and I'm amused, like by the way you handle
By the
stuff.
way, they have no idea who I am.
No, but we know who you are. So we were just wondering if we could just get a picture of you.
Let's skip that part.
I'm okay with it. Yeah, I'm okay.
I know
with
there's
it.
like
Just let
I
me
don't know photography about, but
let me just do a couple things here and there, and then if you just give me a couple minutes, I'm happy to take a
All right,
picture.
Judge, I've got to actually run to another court, so if you don't mind, can I leave them in your jury box?
No, not in the jury box.
Okay.
Where?
The witness stand?
Oh, yeah, if you can hang out in the witness stand here.
Absolutely.
Good morning, ma'am. Ma'am, you are charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance and made contact with the reportee who stated the defendant had left the scene. While speaking to the reportee, the defendant drove up to the scene and the law enforcement officer observed the defendant exit out of the driver's side of the vehicle and was the only person in the vehicle. The law enforcement officer observed the defendant to have red, glossy eyes and slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN. A 3 out of 4 was recorded on the one-legged stand. It states here that the other test was refused. The law enforcement officer found an open alcoholic beverage, mostly empty and cold to the touch, in the center cup holder and several other unopened alcoholic beverages cold to the touch. The defendant refused to provide a specimen. Blood warrant was obtained and executed.
Did you say that there was an accident initially that brought them to the attention or what?
Judge, it just says that the law enforcement officers were dispatched to a disturbance and the defendant drove back to the scene that she had left from.
My fiance.
Stop. Don't. You have the right to remain silent. Exercise that right.
There's no accident, Your Honor. It was just, they were called out to a disturbance. I believe it was a disturbance with. There's a disturbance under the weapon call, Your Honor. They drove up to the location, and made contact with a complainant witness who stated, that the defendant had left the location, and then while they were speaking to the complainant witness,
That's when she comes back.
that's when the defendant came back.
Okay. All right, Ms. Morris, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive at all. I'm now going to have you sign an affidavit with me today promising you're not going to drive. I don't care what is going on in your life. You will be signing an affidavit with me today promising you're not going to drive. Do you understand? Because this is a second offense, you will be required to obtain a portable interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. I will also randomly test you for drugs. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, ma'am? You're sending notice to DPS now that I'm placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock. If you're caught driving a vehicle, it doesn't have an interlock on it, an officer in this state will know that you're required and they will arrest you and put you in jail. And you're in violation of these bond conditions. Do you understand? You have the ability to hire a lawyer, man. We're going to give you time to hire a lawyer. So what I'm going to do is I'll have you go to Victoria, sign a reset. I'm going to first have you come up here, swear test that you're not going to drive. You will then get with pretrial services for your bond conditions. And then after that, you'll be free to go. Do not use. Do you understand? Alcohol or illegal drugs. It's not going to go well. I didn't say you couldn't work. I just said you. I'm warning you not to drive.
They put an interlock in there already.
Okay. Right. Mr. Martinez that I just got appointed to, he wanted to ask you if he's working, he works a lot of times out of state, he does mill work. And you have him come up, Judge? He wanted to know about drug testing. If he's working out of state and they call him for drug testing, can he?
Have to go to Quest.
He's gonna have to go to Quest Diagnostics? Okay.
Come up.
And so sometimes he'll get a job assigned to him where he's working like in Virginia for a week and then he comes back to Houston. Is that correct?
Diagnostic is all over the country and that's who you need to use to test. If you don't test,
No,
then
that was my main concern, because I heard you, here's somebody like, well, they might send me out of town just for a week or two. And I just want to know if it was okay if I go request what you were saying.
no travel restriction as long as you comply with your bond conditions. You have to have the interlock, the portable device, right? Do not drive. I'm telling you, things will go hell-bent sideways if you drive.
When I'm out of town, when since I don't have a driver's license, I don't touch their vehicle. They fly us out everywhere. They drive us everywhere.
Don't
Strictly
drive.
work.
Right? Okay.
Thank you, Judge.
For Miss Simmons, I just picked up her case today. There was a bond condition. So she's telling me there's a bond condition of 500 feet. They're like neighbors. So, and it's like HUD housing. So I was wondering if we could just do no contact and that would be okay. There's even like a comment.
Really? You got the club?
There's even like it's HUD housing. So there's like a common area with a kitchen and all that. And so, I mean, I don't know how they can't.
I don't want, and I don't think it's fair for the complaining witness to have to try to walk on eggshells in hopes that she doesn't run into her. And I want to alleviate any kind of accidental run-ins. That's why we do it. I get it. But so how can we creatively find a way where the complaining witness doesn't have to, oh shit, how am I going to get home? I mean, am I going to run into her? What am I going to,
Yeah, well, I mean, it's HUD housing and she will be homeless if she has to leave.
I'm
So,
not telling her to leave. I
right.
just don't want them to accidentally bump into each other.
Yeah, well, I think the issue is the nature of where they live is like, they would be within 500 feet in their own respective apartments. And so that's the issue.
How do we really know that? We're taking her word for it?
I mean, I can go over there and take pictures and
I don't want
stuff,
you to do it.
but
Can you do me this? Do you mind reaching out to her right now? If you can, how do we alleviate the situation?
Right. And as soon as I have the contact information,
Well, you don't have the contact.
usually with these cases, it's not complaining case. Is to resist.
this isn't a
Oh,
small.
this is, I'm sorry, I thought you were first.
No, we already did that other one.
Okay, I'm sorry. This is, my bad. My bad.
Can you go real quick?
Yeah, I'll.
2 minutes and see, can you give me 2 minutes, Sarah? See,
I have to go to 11, but I will be back. They're already emailing me like,
Close it later. We'll call it there.
okay,
and
I'm being stretched thin.
11 is that, oh, no.
You don't want to, yeah.
Okay, I know, no.
Again, no contact is fine. It's just the 500 feet part that is like impossible in this situation.
100 feet?
100 feet? 100 feet?
If I have to, I'll go down the stairs. We've got an elevator and stairs.
There's always another way in these apartment complexes, you know?
Pardon me?
I don't want you to run into her.
Oh, I understand, sir.
So find an alternate route so that you don't cross in front of her house or apartment, you know? Take the long way if you need to,
Okay,
you know?
okay.
So I'll modify it to, you know, I guess 100.
Okay.
Just, I don't
Yeah,
want her
that-
anywhere near
yeah.
her. it really sucks to have to walk on eggshells when you're
No, I
just trying to.
understand. I understand that. It's just, it's like the nature of where they live that I don't want to make, because she's living there. I don't want her to pick up a BBR because she's just living there, you know?
I'll set that. I'll-
Do you want to go run 11?
Sure. Okay, I'll be back.
So Vicente Rodriguez is on the jail docket for today.
Is this the guy we took in?
No, he's been in custody since.
And look like you're,
Huh?
you okay?
Yeah. No, I just did 2 trials in 2 weeks and I've got 2 more.
That's where you're killing it. Good job.
So Rodriguez.
What is the name?
Yes. Rodriguez.
Oh, Steve Rodriguez.
He's got a couple of cases.
He's on the jail docket?
Yes.
He's not trying to cross line.
Oh, okay.
But
Do you have a cause number?
Yes.
Okay, what is it?
I'll just give you 254-6977.
Oh, this gentleman.
Yes.
Okay,
We would like to set his cases for trial.
okay.
So
Yeah,
just go back to Ramona.
sure, whatever day you want.
Okay, perfect.
Yeah, absolutely. Are you ready, State?
plans aren't board yet, Jeff.
Okay. Do you care which one?
Let me, before I make that determination, I want till Monday, he is set for Monday, before I make determination which one, but.
You care? I mean, I guess of course you do.
Well, I mean, I do.
Right, I mean,
He's been in custody and he's close to maxing out and I can't just have him sit in jail.
He also hasn't made bond on the felony too.
Right.
You know, so it's not like that's the only
I
thing.
know, but I just,
Yeah, okay.
I have to-
Really, whatever you want. I just want to make sure that there's a meeting of the minds
Yes.
as far as which one we're going.
yes.
That's
And
it.
we can put them all on the trial docket and decide which
yeah,
one.
that's what I kind of, my guess.
Oh.
Okay,
Don't have to do that.
Okay.
I'll let you know.
Yeah.
I'll let you know.
okay,
Done. Okay.
thank you.
Sure. It's what?
This is not about a fugitive. I just want to let you know, today's my last day, so.
Oh, really? So where are you going? What are you doing?
Okay.
Where?
For now.
Ah. So you, today, what are we in, April? So you take the July bar. Have you started your barber yet?
Yeah, a little bit. We've been doing practicing fast, so that's kind of the.
So what'd you think? Did you have fun?
Of this, for this, or?
It's great, it's fun, right? So are you gonna try to come back here?
I would love to, I really will.
You should, you know, it's just, nowhere will you ever get more trials than in the trial, in the criminal realm, because in the civil side, it's just, you know, it's paperwork but here, just it's,
Exciting, it's always something new happening.
we're having a little shindig after work now for Joe, so stop by, right?
Sorry, what's up?
For Joe, it's his birthday, so we're gonna have a little shindig right after court now, so, hey, you know, come on by. Yeah. Hell day, you know?
He's not here today.
Oh, that's right. Well, yeah, if you need anything, let me know. I'm happy to, you know, here, come on back.